Hello, SBAM members. This is Brian Kelly, CEO of the Small Business Association of Michigan, with some really exciting news I wanted to share with you today and also some explanation about what it means. You've heard a lot from us about the Corporate Transparency Act over the course, really going over years, as this was something proposed and then became federal law, and then our decision a year ago to challenge that law in court. And we were very excited about a decision that came from a federal court just recently affirming our position that this is a violation of your constitutional rights. We had an outstanding law firm, really the best law firm that was representing us in this matter, and came out with the win. And we want to have a quick conversation about what this means for you and talk a little bit about the future as well. So I have joining us today Steve Van Stamport from Miller Johnson. And Steve, welcome and congratulations on such a robust win. So let's start with describing the case and the win and really what it means.
Yeah, hey, Brian, thank you so much for this. Of course, we here at Miller Johnson are very proud to represent the Small Business Association of Michigan. The association should be proud as well. I mean, this is a big case. This is an important Fourth Amendment decision, important issues at stake, and obviously significant for everybody's bottom line as well. Just as background, we filed this lawsuit almost a year ago, and challenging the Corporate Transparency Act, the reporting obligations underneath it, and the reporting regime that was created by the act on a variety of different grounds. We argued that Congress didn't have the power to do it under Article 1, and we argued that it violated the Fourth Amendment as well. And we won when it counted. And just the other day, the district court granted our motion for summary judgment. And it concluded that the Corporate Transparency Act is actually unconstitutional because its reporting requirements violate the Fourth Amendment. So as of right now, the Corporate Transparency Act is not enforceable as against the Small Business Association of Michigan and its members.
So that's great news for our members who have been kind of on this back and forth, kind of a ping pong. Do I have to report? Do I not have to report? And so you'd mentioned it's not enforceable against the Small Business Association or its members. What about those who have already reported? There are many that had to report in 2024, according to the rules before the decision came down, others that voluntarily reported earlier than the final deadline. What does the decision mean for them?
Yeah, so and I'm happy to talk about the specifics of the court's reasoning too, if you'd like. But the ultimate outcome, right? The court's judgment, it says that the reporting obligation no longer applies. So anybody who hasn't yet reported, who's an SBAM member, who has not yet reported, doesn't have to. For those folks who have already reported, what the judgment order says is that the government is precluded from using their information that has been reported to FinCEN. So that information may be in a database somewhere, but the government can no longer access it and can no longer use it against those members who have already reported it.
Yeah, so a great outcome, even for those that were proactive and decided to report early or had an earlier reporting deadline in place. So what does we're going to get into some other practical things here in just a minute. And it is, it's not very often when it's like, look, this law is unconstitutional because Thomas Jefferson said. I mean, this really is so fundamental to just the foundation of our country from literally the earliest days. A huge deal. Before we get on to the current IRS posture, what do we expect to happen next? So we won at district court. What would be, under normal circumstances, what would happen next?
Yeah, so this is a big deal, right? And it's not every day that a federal statute is ruled unconstitutional, and it certainly isn't every day that it's ruled unconstitutional because it violates the Fourth Amendment. As you said, Brian, we're really getting back to first principles, right? Whether these searches are reasonable. And the court, really went back to the beginning and ruled in our favor. So this is a very significant ruling from the district courts, the first in the nation on this particular ground. So that's very exciting in and of its own right. Under ordinary circumstances, we would, of course, expect the government to appeal this. They have 60 days in which to do so. But given the current posture, right, we're not entirely sure what's going to happen. So we have 60 days from the date of the decision in which the government may or may not file a notice of appeal. If it does, then there are a couple different procedural things that happen along the way, but it would go up to the United States Courts of Appeals for the Sixth Circuit, and it would be litigated there, and the courts would then, the appellate courts would weigh in on the constitutionality of the CTA from there.
All right, so we will likely, there'll be more to the story later on. So let's talk about the IRS in their current posture. So they have sent several signals, including and taken actions. So say number one, they're not going to enforce this until they publish a new rule or they propose a new rule. And there's a whole process of a public hearing and consideration for the information of the public hearing before a proposed rule becomes final. And they've also said that they plan to scale back the types or the number of entities that need to report in the future. We don't know exactly what the new rule will say, but the sense is that they're going to scale it back very substantially. So it really begs the question, why does this case still matter if the IRS does follow through with their statements and the impression that they're leaving, that they're going to significantly scale back the rule? Why does this matter?
Yeah, thank you, Brian. So it's true that Treasury has articulated that it's not going to enforce this particular the statute as it currently exists against domestic entities, and that they're planning to introduce a new rule that will limit the scope of the reporting obligation to foreign entities. Now, there are a couple things to be to note about that. Number one, if that's a regulation, if it's administrative regulation, really that's going to be limited to this particular administration, right? And so, a couple of years from now, 4 years from now, if administrations turn over, all of that regulatory apparatus, that could be changed. It could be changed back to the very broad and sweeping regulations that we saw that the district court just enjoined. So that's number one, why it matters. It matters on a going forward basis, kind of in the long term, in the event that the regulatory posture has changed. Second, even in the short term, it's not clear how the interim rule is going to look, how it's going to function, and most specifically, what's going to be defined as a foreign entity. There may be potential, there are a lot of different permutations, right? It could be any entity that's formed overseas and then registers to do business here, but it could also include an entity, a domestic entity that has an owner, a foreign owner, right? And so that could sweep up, many small businesses that potentially have a Canadian citizen, for example, who has an ownership interest in a domestic entity. So we're not sure what that rule will look like. So we're not sure that rule will be as salutary as we currently hope. And so that's why it's important that we have this district court decision, which takes care of all of that, right? None of that stuff is going to be constitutional if this district court's order is upheld on appeal.
All right. Well, we appreciate the insights. So anybody who is a member of the Small Business Association of Michigan, and if you're receiving this email, it means you're on our membership list, and so we would really love to. We would love to stay in contact with you about where we go from here. So you will hear from the Small Business Association of Michigan in the future if the government chooses to appeal, and we will be right there to carry through this decision until somebody has a final say. Who knows? Maybe we'll end up at the United States Supreme Court before all is said and done. Steve Van Stamport from Miller Johnson, thank you so much for your excellent representation here and for joining us today to let our members in on the exciting news and what they can expect going forward.
Thank you so much, Brian.